Hi, my name is David P. Shapiro. I'm a San Diego criminal attorney, and I'm also the owner and managing partner of the law office of David P. Shapiro, where our firm helps good people regain control of their future when charged with a crime. Today, I want to discuss with you the offense of battery resulting in serious bodily injury. Usually we see that under Penal Code Section 243D, as in David, and it is a serious offense. It is a serious offense to be taken seriously, and I don't keep using these terms seriously for no reason. It's important because if you're convicted of battery causing serious bodily injury, it is a strike felony. It is a serious felony under California's 3 strikes law. So if you're convicted of it as a felony, the stakes are extremely high. Now, battery we usually see in the context of a fight or a physical altercation. And a lot of times people, through their own statements or their own admissions, wind up sinking their ship and their best possible defense by talking to the police, by talking on social media, by talking to friends about it. Because then during the investigation, what winds up happening is all this talk, all this social media, all this stuff on your cell phone winds up giving law enforcement and the police and the district attorney's office and eventually a jury, if the case goes to trial, all the evidence in the world they need to convict you of battery causing serious bodily injury. Well, what are some good defenses to battery causing serious bodily injury? Well, one is it wasn't me. Whether I was there and it wasn't me, or I wasn't there at all, a true alibi defense. But again, if you start talking to the police, if you start talking to your friends, if you start using social media about the offense, very likely what you're doing is you're closing the door to that defense because now you're admitting you were somewhere. I give an example all the time whenever someone comes in and meets with myself or a team member at my firm. And we tell potential clients, the example of, our office is located in San Diego. And if you leave our office at 4 o'clock in the afternoon and you get pulled over at 4:15 and the cops want to talk to you about a murder that happened in Orange County at 3:30 in the afternoon. Well, assuming the officer's telling you the truth, there's no way in the world that you would have been in Orange County at 3:30 because you were in my office from 3 to 4 o'clock. Don't even tell them that. Don't lie. Don't volunteer all this information because you don't know if they're telling you the truth where this murder actually occurred, where this murder actually took place, and at what time. So that's an extreme example of I politely declined to answer any questions without the advice and consultation of my lawyer. That's all you need to say. I think you don't close the door to a possible alibi defense. The other defense is self-defense. And I don't want to get too much into the legalese of what self-defense is and what self-defense isn't. But it's definitely a good option. But a lot of times people close the door to that by talking on social media, by saying things that completely destroy any realistic shot they have of having a good self-defense case. So the underlying message is when you're charged with any offense, particularly battery causing serious bodily injury, keep your mouth closed. Don't talk about it on social media. Don't talk about it to the police. Don't even talk about it with your friends. You don't want to turn people into witnesses when they don't need to be, when they don't want to get involved in it, I'm sure either. So the best thing you could do is reach out to a firm like mine, a quality, locally experienced criminal defense law firm. And I say law firm as opposed to one lawyer doing everything, because we are a law firm, fully staffed. We have people on call for you to be able to help you navigate the system and help you regain control of your future. Feel free to give us a call at 619-295-3555.